June 11th of this year, a United States District Court in the Southern District of New York ruled that Fox Searchlight Pictures violated federal and New York minimum wage laws by not paying their production interns. The court also granted class and conditional certification for corporate interns. This decision has received international media attention and could have wide implications for businesses that have interns. My guest is Outten Golden's Sally Abramson. Sally, welcome. Can you give us a brief summary of what the court's ruling in Glatt v. Fox Searchlight was?
Sure. The court found that Glatt and Footman were employees under both state New York law and federal law, and that they should have been paid. In coming to that decision, the court looked at the kind of work that both of them did, things like making copies, picking up paychecks, making travel arrangements, and said that's the type of work an employee does and needs to be paid. In coming to that decision, the court relied on the Department of Labor's 6-factor test for whether or not an internship can be unpaid.
Sally, can you review what the Department of Labor's intern criteria actually are?
Sure. So there are 6 of them. One is, and a very important one, is that the intern program must be akin to an educational or vocational program. They don't have to necessarily sit in a classroom, but it has to be something that is similar to what you would get at either an educational or vocational training program. The other is that the program really needs to be for the benefit of the intern. It can't be providing immediate benefit for the employer. The employer can't derive immediate advantage from what the interns are doing. Some of the other factors that the DOL lays out is that the intern has to know that they're not entitled to a job at the end of the program, and the employer and intern have to both know that they're not entitled to wages. All of them have to be met in order for them not to be paid. And so if an employer is getting immediate advantage from an intern, or the program is set up in a way that's not really akin to an educational or vocational training program, the intern needs to be paid. And in this case, the court found that Glatt and Footman didn't derive anything that they wouldn't derive if they had just been an entry-level employee. The court said there are things that entry-level employees, benefits that they get, such as being able to put something on your resume, getting on-the-job training, learning the way the company works, and those are things that, quite frankly, as a new associate, I learn things. Just learning something doesn't make it an educational or vocational program. The other thing that the court looked at was that Fox derived direct advantage from this work. The court actually said no matter how menial the tasks may have been, just making copies or picking up paychecks or making travel arrangements, those are things that otherwise a paid employee would have done had they not had these interns.
Sally, it seems like this ruling could have some broad implications. I mean, it sounds like many companies have interns doing jobs that they would normally pay other people to do. Is that correct?
I don't know if that's what they're usually companies across the board are doing, but that's definitely a common thing in which, the classic intern is making photocopies and getting coffee. And those would be productive tasks that they need to be paid for.
Sally, what do you think the implications of this decision will be?
I think that companies are going to take a hard look. This got a lot of media attention. I think when there was the economic downturn in 2008, a lot of companies started having or expanded their unpaid intern programs. I think sometimes these programs replace entry-level employees. What is not okay is to just replace the word intern in front of entry-level employee positions and then not pay them. And so I think companies are taking a hard look. I've also been really pleased with the way public perception has seemed to grown about this. I remember seeing that Sheryl Sandberg's nonprofit had a posting for unpaid interns, and there was wide public outcry about it. And within, I think, a week or a couple days, Sheryl Sandberg said the position would now be paid. And so I really think that the public awareness is growing, and I think that's great. I also think that interns are now going to have a leg to stand on in either negotiating pay, or using this to really push companies to create programs that allow them not to pay their interns.
Do you think that companies often have a misconception that if an intern is getting college credit that they don't have to pay them?
That is, and it is a big misconception. Whether or not a company has to pay their interns really depends on the program that the program that the employer has set up. So what the judge said is that it doesn't really matter if you got credit. That doesn't really demonstrate, that demonstrates the college, whatever university or college you're enrolled in, and who knows what kind of program they have set up. But that doesn't demonstrate what program the employer set up, because really the DOL, the Department of Labor factors, go to the employer's program for the interns, and not the individual experience of each intern.
Well, finally, Sally, what can a company do to make sure that they're complying with the law? It sounds like justifying an unpaid intern position could be very difficult.
I think that's probably correct. I think the safest thing for an employer to do is to pay their interns. And if they're not going to do that, they really need, probably to get legal counseling, and they need to make sure that they are complying with these 6 factors that the Department of Labor sets out, which means that they are setting up an educational or vocational program, and that this program is even maybe at times impeding their business. So it really isn't something that they're getting a productive work from the interns from. It's more something that they set up for a learning experience, and that may impede or cost them.
My guest has been Outten Golden's Sally Abramson. Sally, it's a pleasure. Thanks for joining us today.
Thank you.
I'm Scott Drake. You're watching the Employment Law Channel, an affiliate of the Legal Broadcast Network.